Welcome to this 1 hour CPD seminar, an update on work health and safety law, March 2020. Normally, the seminars like this are live streamed in front of a group of people. So this is a first for us. We're only recording this as a result of the coronavirus limitations. So we're going to be doing this with no audience. A bit like the Australian cricket team playing against New Zealand. I think that's the only time I can ever draw a comparison between myself and the Australian cricket team. Now we have a content-rich hour. We're going to have 3 separate presentations in this hour. Our first speaker, Malcolm Scott, is going to be dealing with foreseeability and specifically considering 2 recent cases that raise the question of whether a successful defence can be mounted in circumstances where the risk arose because a highly trained and experienced employee took an unexpected course of action. Then Carmel Lee, also of Greenway Chambers, is going to talk about a case that's recently been argued in the High Court, known as the helicopter case, which raises the issue of whether a company can successfully prevent an employee from being required to give evidence after they have been charged on the basis that that would be contrary to principles that underpin a criminal trial. And then, with what time is left in the hour, I'll give a short presentation on costs. Now, before I throw to Malcolm, can I just say that for those of you who are watching this as a result of getting a link to the video, you will have also in that email been given links to papers on each of the 3 subjects that we have written. For those of you who are watching this CPD, having found it on the website, if you want to find the papers, I'm told the place to go at the top of the screen, you will see Develop. You might even have come through that heading in order to get to the CPD videos. Under Develop, you'll see a subheading, or the next screen, Articles. And then within Articles, if you select as a practice area, Industrial and Employment, you'll see all the CPD videos that we've been doing on that area. But this one, the papers relevant to that will be found in that section. Now, the 3 topics we're covering, each of them could occupy in and of themselves an hour. So we'll be giving you an introduction to the areas. The papers deal with them in detail, but it has struck us that if there are people watching this who would like to get an extended version of one of the papers presented as a CPD, message, email, let us know, and we will seek to pre-record so you can access a CPD of a longer variety on that particular subject. Okay, well, without further ado, let me throw you over to Malcolm Scott. Malcolm.
Thank you, Ingmar. This is a lot easier to follow if you have the paper. And you have read the paper, or you are reading the paper as we are speaking together. The issue has been brought to recent attention. It's not the first time, it's a reason that I will deal with, by 2 particular decisions out of the District Court in 2019. First is Orr and Cobar Management Proprietary Limited, which was 27 May 2019, which was a judgment of Judge Scotting, and the second one is Orr and Hunter Quarries Proprietary Limited, which is a judgment of Judge Russell, which is 8 November 2019. And I'll come to those, the reasoning in those 2 cases later. The issue, I think, can be best posed as a question on the following terms. Is there a point beyond which the actions of experienced, highly trained workers who put themselves at risk of injury in a manner which is inexplicable or unexpected can be considered to be not reasonably foreseeable. And the context that I pose that question is this one. The relevant action occurs during the completion of a task, and that task involves exposure to risks to health and safety. Those risks have been recognised, and in respect to which those risks, the PCBU has put in place procedures and policies to overcome them. Why this is particularly relevant is that there is a premise that if the actions of the worker are not reasonably foreseeable, then it's hard to discern what the PCBU could do that is reasonably practicable to prevent or minimise the risk. And on that basis, then the prosecution would not succeed, because that is one of the elements of the offence. Now, there's a common law duty, and that's where we need to start. I don't have a clicker. I'm sorry. I'm being asked to click onto screens, but I don't have a clicker. We start this whole area with a discussion of the common law duty. Thank you, Ingmar. So I'll do that again, and we can edit this a little bit. We start this whole discussion on the basis of there being a common law duty, which has been described for many years by the High Court. The case, as you can see from the screen, is Dunlop Rubber Australia and Buckley. Now, in Dunlop Rubber Australia and Buckley, there is a much off statement of Dixon, CJ, who was, in his turn, restating something that Denning LJ stated some years earlier. And that, the effect of that is this. He says, it may be unlikely that they will act in such a way, but it is not only the likely but also the unlikely accident against which the occupier must guard. He must guard against all conduct which he can reasonably foresee. The limit of his responsibility is only reached when the machinery is safe for all except the incalculable individual against whom no reasonable foresight can provide, the individual who does not merely do what is unlikely, but also that which is unforeseeable, or at least not to be foreseen by any ordinary man, one should say, and woman, obviously. Now, that's a test that the High Court applies to the standard of duty owed by occupiers to visitors to premises, and also employers with regard to their employees. Under the prior Occupational Health and Safety Act, there was a Section 53, and the Section 53 was a defence. That was a defence that the company could run, that it was not reasonably practicable for that company to ensure the health and safety of their employees. Now, this was raised in SRA and Dawson, which is a 1990 case of the Industrial Commission of New South Wales in court session. There was an appeal from the industrial magistrate related to a linesman who had been electrocuted when he placed his left foot on one part of a line structure when lines were being inserted into the Lawson train station. There were, the employee himself was experienced, well trained. There are other methods of work that he could have used, and unfortunately he chose one which caused him to be fatally injured. The focus of the case was with regard to supervision and whether or not the foreman should have hung around and told him exactly what to do at the point in time. The Commission in court session said that no amount of qualified supervision could have prevented the actual movement by Mr McFadden in placing his left foot in the channel arm. The evidence is, which we accept, he did it for some inexplicable reason. So that's the starting point. They've decided this person has done something which is inexplicable. They don't know why he's done it. They then go on to say, at page 125 of their judgment, that the company had laid down a procedural system of work to meet the eventuality of people working in isolated areas. And they go on at page 125 to conclude it was equally consistent for the accident to have occurred by reason of a casual omission by the foreman in the allocation of work to Mr McFadden and in the supervision of him in the performance of that work. The appellant, in our view, having laid down a safe system of work, has not done or omitted to do anything causally connected with this tragic accident. What occurred was beyond the employer's control. Now, this was picked up again by the Commission in Court session in Jenner Constructions Proprietary Limited and WorkCover. Oop, I should have hit this button, I'm sorry. Jenner Constructions Proprietary Limited and WorkCover. This was an appeal from two judgments of Justice Kavanagh. It related to the death of an employee who was struck by a reversing truck that was engaged in roadwork at the side of a major road in the Southern Highlands. The movement of the truck on the day was not in accordance with the usual procedure. There was an appeal. The Commission in Court session dismissed the appeal. However, it made a few very pertinent points in doing so. The first one, in paragraph 67, is as follows. It may be that in some cases it would not be practicable to guard against a detriment to safety occasioned by an appropriately trained and instructed employee departing from a known safe procedure. This may be so because the risk of the employee failing to follow procedures was not reasonably foreseeable, or in a comparison of the training and instruction required to ensure the employee adhered to those procedures with the risks created. There are limits to the degree of instruction which can be expected to be provided to an experienced employee. Now, that line was picked up again by the Commission in Court session via Justice Walton in the WorkCover Authority and Kirk Group Holdings, where he states, rather, to the extent that the behaviour of careless or disobedient employees may not be reasonably foreseen, that is a matter which may properly be raised in relation to a defence under Section 53 of the Act. That is, the unforeseen behaviour of a disobedient employee may well lead to the happening of an event that could not be reasonably foreseen, and therefore which is not reasonably practicable for an employer to guard against. Now, in Kirk and the Industrial Court of New South Wales in 2009, the High Court doesn't deal with this particular issue because it doesn't need to. It finds there are other grounds to overturn the judgment. But Justice Hayden at paragraph 120 quite brutally states as follows. Yet another curious feature is found in a section of his reasons for judgment recording various facts which he evidently saw was crucial. The trial judge there concluded Mr Kirk did not supervise the daily activities of the employees or contractors working on the farm. The suggestion that the owners of farms are obliged to conduct daily supervision of the employees and contractors, even the owners of relatively small farms like Mr Kirk's, is with respect an astonishing one. A great many farms in Australia are owned by natural persons who do not reside on or near them, and a great many other farms are owned by corporations, the chief executive officers of which do not reside on or near them. The suggestion reflects a view of the legislation which, if it were correct, would justify many of the criticisms which counsel for the appellant subjected it as being offensive to fundamental aspects of the rule of law on the ground of imposing obligations which were impossible to comply with and the burdens to which were impossible to bear. Now that brings us up to the recent decisions. First one is ore and cobar management, in which Judge Scotting was considering the prosecution of a defendant company, which was consequent upon a miner having drowned in a sump of water underground. He drowned as a consequence of placing himself in the water for the purpose of unblocking a drain. The drain having been unblocked, there was such water pressure pushed up against his body that he wasn't able to get out, and he drowned. Now, His Honour firstly summarised the authorities relevant to the breach of duty, and then he goes on to say the level of water in the sump at the time of the incident was unprecedented. He goes on to say it was unnecessary to enter the water to unblock the drain hole. This was demonstrated by Mr Hearn's first attempt to unblock the drain hole with a scaling bar. He goes on, it was not reasonably foreseeable that a worker would deliberately enter a large body of water in order to unblock a drain hole. He says the defendant did not know Mr Hearn was going to enter the water whilst attempting to complete a task of unblocking the drain hole. He had not been instructed to enter the water and only did so to retrieve the scaling bar that he lost in his unsuccessful first attempt. His Honour concludes, I am not satisfied the pleaded risk was reasonably foreseeable. He states, whilst it was within the limits of imagination to anticipate a worker may enter the water into it or fall into it, I am not satisfied that this demonstrates it was reasonably foreseeable that he would do so. Further, he states, Mr Hearn knew of the risk posed by entering the water to unblock the drain hole. Mr Hearn was in breach of the company's safety system on a number of specific respects, and he magnifies that. I am satisfied there was a significant possibility Mr Hearn would have gone into the water to retrieve the scaling bar even if he had been prohibited from entering the water. He states that he was satisfied that the training provided the workers at the mine, they knew that the work in the mine was dangerous, and in order to prevent risks to their health and safety, it was essential they complied with the procedures that they had been trained in. So he found that there was a good system of work, people had been well trained, this was something that hadn't happened before, and he found there was no expectation on any level that the employee would put themselves into that area of risk and therefore was not foreseeable. The second case is that of His Honour Judge Russell, Ore and Hunter Quarries. Now this is a case where a person was driving an excavator on a quarry, and that excavator rolled when it was being operated by Mr Messenger on uneven ground. It was found that shortly before his accident had taken, Mr Messenger had taken steps with regard to the operation of the excavator which was contrary to well-known safety procedures that had been put in place. Now, His Honour, paragraph 342 states, I think what will be repeated again and again in that jurisdiction in matters of this kind. He says, while a person conducting a business or undertaking must guard against the possibility that an employee may be careless or inadvertent in carrying out a task, there is a line to be drawn between such behaviour and the deliberate and unforeseeable flouting of rules in the workplace and the training given to employees. He goes on to say, in this case, that on all the visits by the inspectors to the quarry and in the experience of all employees of the quarry who gave evidence, no one had ever seen an excavator being operated after driving across a bund in a no-go zone, across a slope, on unstable ground, or with a boom fully extended near a high wall. He states then at the following paragraph, on the day of the accident, it was not reasonably foreseeable. It follows there was not reasonably practicable for the defendant to take provision against the happening of such an event. He goes on to say there was no risk assessment conducted of the potential for the excavator to overturn when working on rocky, unstable ground where the accident had occurred because no one knew or could have foreseen Mr. Messenger would have operated the excavator in that location in the fashion that he did. He finds that the defendant did have adequate work procedures for assessing any potential for the excavator to overturn, requiring the work to be done in a fashion which eliminated the risk of the excavator overturning. And he states, finally, I have previously found the way Mr. Messenger was operating this excavator on the day was against all instruction and training of which he had been provided. Again, it was not foreseeable to the defendant that Mr. Messenger would have acted in this fashion. I find that in any event, adequate information, instruction and training have been provided to all excavator operators by the defendant. There was no failure to ensure a safe system of work in that respect. So, again, reasonable, safe system of work, well-trained employee, experienced employee then does something which is largely inexplicable in terms of the actions that they've taken, and that leads to them being put at risk of their health and safety. Now, whether these cases will survive the scrutiny of the Court of Appeal is yet to be seen, but the fact is we have in 2019 two of the three judges that do this work in the District Court who have brought down judgments which delineate in their mind this concept of unforeseeability based upon the actions of a particular employee. To answer the question that I posed at the beginning, on the basis of the reasoning of Judge Russell and Judge Scotting, the answer to the question starting this talk is yes. In other words, there is a point beyond which the actions of experienced, highly trained workers who put themselves at a risk of injury in a manner that is inexplicable or unexpected can be considered conduct that was not reasonably foreseeable, and therefore conduct for which a prosecutor will fail to successfully prosecute. Now, that being said, I hand the matter over to Carmel Lee.
We're running well in time, Carmel, so don't feel you have to rush too much.
Thank you. Thank you, Malcolm. Today I will be speaking about the helicopter case. Helicopter Resources Pty Limited and Commonwealth of Australia. My talk will be in the style of a brief case note. I have published a paper on this topic, and that will be available at the Greenway Chambers website. Briefly, I think that this case is significant for practitioners in this area, as it demonstrates the developing case law about compelling evidence from a corporation once the prosecution of that corporation has begun. It also demonstrates the possibilities of the statutory framework at the moment in terms of compelling evidence from a corporation. To summarise the facts briefly, the Commonwealth of Australia, Commonwealth engaged Helicopter Resources, as you'll see, to supply helicopter services to the Commonwealth. And that was at the Davis Station in the Australian Antarctic Territory. On the 11th of January, Captain Wood landed a helicopter across a hidden crevasse in the ice, and whilst reboarding that helicopter, Captain Wood slipped and fell into the crevasse. He died the following day. The procedural history of this case is as follows. In September of 2017, there's a hearing of a coronial inquest into Captain Wood's death in the ACT. In December of 2017, Helicopter and the Commonwealth were both charged as co-accused with summary offences under the Work Health and Safety Act 2011 Commonwealth. In January of 2018, the Commonwealth requested that the defendant's co-pilot, Captain Lomas, be available for cross-examination at the incident, in relation to the incident. And Helicopter then applied for the coronial inquest to be adjourned. That the Commonwealth, on the other hand, submitted that the inquest should proceed. In 2018, the Chief Coroner rejected the application by Helicopter and issued a subpoena for attendance to Captain Lomas. Helicopter sought judicial review of the Chief Coroner's decisions before the Federal Court, and in June 2018, Justice Bromwich dismissed Helicopter's application. That then brought it in February 2019 before the full Federal Court and allowed appeals by Helicopter, and it stayed the subpoena. So why is this decision significant, and why are we looking at it? It's significant because it looks at Section 87 of the Evidence Act particularly, and that is admissions made with authority. Significantly, this Act has the same wording as the New South Wales and the Commonwealth Act. Section 87(1)(b) has the effect that out-of-court statements made by an employee of a party, whether they're a natural person or a corporation, on employment matters, if adverse to the interests of the party, could be admitted as an admission by that party. This would be admissible against a party under Section 81 of the Evidence Act as proof of the matters asserted to. And there have been exceptions to the hearsay rule under Section 59 of the Evidence Act. What does this mean? Captain Lomas was a key employee of Helicopter. He was responsible for many of the organisational aspects of that company's business. He was about to be cross-examined in relation to those matters and in relation to the incident of Captain Wood's death. His evidence would clearly be relevant to the prosecution of Helicopter in relation to its work health and safety procedures and its work health and safety prosecution. Potentially, evidence given by Captain Lomas in the coronial inquest could be, the transcript of that could then be tendered in the criminal prosecution of Helicopter by the prosecutor, subject to the admissibility rules. How could it be tendered? Because he was giving an out-of-court statement. He was giving that statement to the coronial inquest. He was an employee of the corporation. It was in relation to employment matters. Presumably under cross-examination, he may make some comments that were adverse to the interests of that party. As a result, his comments could be taken as an admission by Helicopter and could be tendered in the prosecution of Helicopter. This would change, this would develop the common law, and it would broaden the category of cases in which an admission could be tendered by Helicopter. Helicopter would in effect be limited, their actions would be limited in the way they ran the response to the prosecution, as it would now potentially have, the prosecutor would now potentially have an out-of-court statement by one of its key employees, which was now to be attributed as an admission by Helicopter. And as a result, of course, Helicopter brought the appeals to the full Federal Court. The full Federal Court, in its decision, considered a number of aspects in relation to this rule. It looked at the companion rule, and it also looked at the accusatorial process. In one of my later slides, I've outlined what the High Court later described as the X7 series of cases. But briefly, the X7 series of cases demonstrated the following propositions. A corporation has no privilege against self-incrimination. However, the X7 series of cases looked at what can be compelled from a corporation during a prosecution process. It demonstrated that documents can be compelled from a corporation, business records, etc., under the best evidence rule. However, interrogatories, being compelled to answer questions once the prosecution has already begun, cannot be compelled from a corporation. That is because one assumes that the prosecutor, in beginning a prosecution at that point in time, has sufficient evidence to prove the guilt of beyond reasonable doubt of the corporation. Briefly, the issues before the federal court were as follows. Whether there was or there would be interference with the due administration of justice amounting to contempt of court or otherwise constituting an impermissible interference with the criminal proceedings by calling the chief pilot, Captain Lomas, to give evidence to the inquest in advance of the criminal trial, and the issue of prematurity. What did the federal court find? It found that anything said by Captain Lomas at the inquest could not be tendered against Helicopter as an admission to it in the criminal proceedings. So anything said by Captain Lomas could be tendered, against Helicopter as an admission in the criminal proceedings, as what I've just outlined previously. This would alter the way that Helicopter would conduct itself in the criminal proceedings. It would go against the accusatorial process by disadvantaging the employer, Helicopter, or advantaging the co-accused, the Commonwealth. And the matter was not premature as it related to a matter of principle. The issue of prematurity was Captain Lomas had not yet been called to give his evidence. The Commonwealth submitted that his evidence might be limited in a particular way, or he may not make assertions that were damaging to Helicopter. However, the court found that the application was not premature. Following the full Federal Court of Appeal, the Commonwealth sought special leave, and they agreed to pay Helicopter's reasonable costs of a High Court appeal to appear as contradictor. This demonstrates the particular interest the Commonwealth has in this matter. The High Court hearing was heard on the 10th of October. The criminal trial concluded without Captain Lomas being called to give evidence. In a further hearing on the 5th of February, Helicopter made submissions in relation to whether or not special leave should be revoked in this matter. Briefly, the questions before the High Court were as follows. Does Section 87(1)(b) of the Evidence Act have the effect that an admission made by an employee with respect to a matter within the scope of their employment is taken to be an admission by the employer itself? If Section 87(1)(b) does have that effect, do the principle in the X7 line of cases mean that an employee of a corporation cannot be compelled to produce evidence that is relevant to the pending charges against a corporation? And finally, was it premature to conclude that the compulsory attendance was inconsistent with the accusatorial process, regardless of what the answers might be given and what safeguards were in place? You can see I've outlined the X7 line of authorities. I discussed those in detail in my paper. So what are lessons for practitioners in this period of time? What are the two key takeaway points? First, practitioners should be aware of what, if any, coercive power is used to elicit information from a defendant after prosecution has begun. The X7 line of authorities discussed that in some detail. Secondly, we can see that the Commonwealth is particularly interested in this case. It is interested in this case not only in work health safety matters, but across a broad number of matters. Thank you. Ningma?
Thank you. Okay, thank you, Carmel. Thank you, Malcolm. So I've got the topic of costs as the last topic we're going to cover in this seminar, and let's just get right into it and start with the proposition that would be familiar to those who practice in this area, that the usual rule applies, notwithstanding that we're in a criminal context. That is, the unsuccessful party is ordinarily going to be ordered to pay the costs of the successful party. And one of the things I'll be doing, or really the main thing I'll be doing in this paper, is talking about when that usual order will be departed from. But before I do that, let's just have a look at the statutory basis for the cost power that is provided to the District Court in New South Wales when deciding these cases. So you'll see there on the slide, the first section 257B is the power given to the court to order that a accused person, or maybe more strictly a convicted person pay costs to the prosecutor. The prosecutor can only get costs upon a conviction. The corresponding provision, 257C, provides the court with the discretionary power to have the prosecutor pay the defendant's costs. There is a precondition, and that is that the matter's been dismissed or withdrawn. And it's important to understand that each of those sections has a precondition. There isn't a broad power to simply impose a cost order on the prosecutor, perhaps partway through a proceeding, or for that matter on a defendant, when those preconditions haven't yet been met. That's subject to something that I'll deal with in a moment when I come to the fourth of the four sections. But before I do so, just have a look at 257D. Those of you who are maybe more familiar with the way these things work generally in criminal matters will know that outside of work health and safety context, in order for a defendant to get their costs, they usually have to establish something more than simply the matter has been dismissed or withdrawn. They have to prove something extraordinary about the proceeding, perhaps going to the way in which it was brought, or some failure by the prosecutor which would justify that order. That section does not apply in work health and safety matters. Hence, as we go back to the previous slide, the usual order is simply if the defendant succeeds, then they would get costs subject to the exercise of the discretion because of facts peculiar to the case, which is what I'll come to. I said I'd come to the fourth dot point. This is the one area where the court has a discretion to award costs other than in cases of a conviction or withdrawal, and that's where a party has caused an adjournment. And the power is to award costs arising from that adjournment. And I'll come towards the end to a case in which that power was used by way of an example. All right, let's just have a look at some broad principles. These are the principles that apply equally, as the Court of Criminal Appeals said in Bolger, which is the case you'll see there on the slide in the second dot point, which is really the leading authority in this area at the moment. These are principles that one finds drawn out of civil law, and for the civil practitioners amongst you will therefore be very familiar. Costs are compensatory. They're not a punishment for failure, and as such you don't need to establish wrongdoing. You just need to establish that you won. What that leads to as a matter of principle is that costs follow the event, the usual rule. That, though, is subject, as the third dot point on the slide indicates, to the fact that they can, however, be discounted for various reasons, one of which is that there are multiple discrete issues and the successful party has been successful only in part. Now, within a work health and safety context, that is the most common scenario which justifies an order of less than the usual order, that is, simply costs to be awarded. That's the scenario which would lead to a judge saying 80% of costs or 50% of costs. And it most commonly arises in a work health and safety context where the prosecutor has sought to prove a number of particulars that in other words, the defendant could have reduced or eliminated the risk by taking one or more of the following steps, and they've set out maybe 5 things, and the prosecutor ultimately is only able to prove one of those out of 5, for example, which is in fact the example that arose in Bolger itself. What the courts have said is that justifies a lower order for costs, but it's not as simple as a mathematical exercise. So in Bolger, for example, only one particular had been made out, but the Court of Criminal Appeals said that doesn't mean that the prosecutor only gets 20% of their costs. What one must have a look at the overall way in which the case was run, and in that particular case, having proven that one particular, the prosecutor was entitled to 50% of the costs. Now, what one finds in Bulger is a reference to matters which the court says are peculiar to a criminal proceeding, which add perhaps to the principles that would otherwise apply normally in civil proceedings, and the two that they identify there on the screen. Now, the first of which is that the defendant chose not to explain things prior to hearing. Now, the court went out of its way to say that we're not suggesting that it's not entirely appropriate for a defendant to maintain an absolute right to silence, but there is a cost consequence of doing so. If the court case proceeds and it becomes apparent that the case has failed in circumstances where the defendant could have explained to the prosecutor in advance some matter which would have reduced or perhaps even prevented the case going forward, then that may be something that's taken into account of costs. The second identified departure, they say, from civil law is where the defendant has unreasonably prolonged proceedings, for example, by unnecessarily extended cross-examination. Although, for my part, I'm not sure that is a departure from civil approach. I think the same approach would occur in a civil proceeding. That is, if a party has unreasonably prolonged proceedings, there usually is a cost consequence. The next thing that's on the screen is not unimportant. It's perhaps reiterating something I've already said, that it's not relevant to whether the cost order is or isn't made, or for that matter, the quantum of cost order, whether it's 100% or less, how reasonable the conduct of the prosecutor was when considering a cost order in favour of the defendant. If the defendant succeeds, the defendant succeeds, and it doesn't matter that the prosecution case was really hopeless or only just failed. Either way, the defendant would expect to get their costs. The only rider I'd add to that is the last dot point. Whilst this hasn't, to my knowledge, arisen since the jurisdiction has moved to the district court, there is some earlier authority when the cases were being heard by the Industrial Court of New South Wales, prior to that known as the Industrial Relations Commission in Court Session. I think you know who I'm talking about. That indemnity costs was something that court at least was prepared to consider in work health and safety matters, but they made clear that there would indeed need to be some exceptional circumstance that would justify moving away from the usual order, which is effectively a party costs order. So if a defendant wishes to seek indemnity costs, then they would, I would think, need to identify something that could include and perhaps would be likely to be significantly focused on the reasonableness of the prosecution's conduct generally, or specifically in respect of the reasonableness of bringing the prosecution at all, given the matters that were known to the prosecutor. So let's have a look at some recent examples of non-standard costs orders that have arisen since the jurisdiction's been moved to the district court over the last few years. So the first thing I've identified is where the prosecutor has withdrawn particulars prior to trial. Now, in both of the cases they're identified on the screen, Nash and Freycinet, prior to the matter actually coming on for hearing, the prosecutor had identified they wouldn't be proceeding with certain particulars, and at the end of the proceeding, the defence sought an order. Now, in Nash, this was actually being considered, in effect, for the first time by the Court of Criminal Appeal, because at first instance, somewhat surprisingly perhaps, certainly erroneously, according to the Court of Criminal Appeal, the judge at first instance had made no costs order, notwithstanding the successful prosecution. So when coming to reconsider it, the Court of Criminal Appeal effectively had to decide at first instance, what cost order should be imposed, and the defendant said, well, hang on, there were some particulars that we were faced with that were withdrawn prior to hearing. And in effect, the same issue came up in Freycinet. The difficulty, of course, for the court in both cases is that it's not in a position to know, without perhaps evidence, quite what sort of costs were involved from the defendant's side in preparing the matter for something that didn't ultimately run. It's not like it can for a particular that fails during the hearing, where the judge has some capacity perhaps to say, well, we spent 20% of the time of the case on that factual issue. And so the order that was made in both of those cases was an order that the defendant pay the prosecution's costs, the usual order, but then with a carve-out, and the carve-out being less the costs that the defendant incurred attributable to the particular that was removed, and less the prosecutor's costs associated with that particular. All right, let's move to the second dot point. The prosecutor is successful in respect of some but not all particulars. And this is, as I said earlier, perhaps the most common way in which this issue arises. And Activate Fire Australia is an example of that, but I'm not suggesting it's the only one. There are a number. In that case, like Bolger, there was a contested hearing in respect of two of the defendants, and the prosecutor ultimately succeeded on only one particular. And out of, I think, again, 5 by coincidence, Judge Scotting determined that the prosecutor having succeeded, the prosecutor should get an order for costs, but only 50% of the costs, not... So which was a mathematical exercise which took into account how much time the court had spent determining the matter, but taking into account that a substantial amount of time of the proceeding, approximately half, had been spent on issues which the defence ultimately succeeded upon. The next dot point deals just with a small matter. It's not unusual for a prosecutor to prosecute on alternate charges. For example, as was the case in this case, where there might be an issue as to whether the worker was employed by or the company or was a contractor engaged on a different basis, that they might put up a Section 19.1 or a Section 19.2 in the alternative. And in this particular case, the prosecutor was successful on its primary charge, and the defendant said they should get some costs because they succeeded on the alternative charge. That got short shrift on the basis that if the prosecutor succeeded on the primary charge, didn't need the alternative, and there was not going to be any reduction in costs merely because it had been pleaded effectively in the alternative. Okay, 3 more issues before I finish up. Firstly, the question of a joint trial. So this is something that can come up from time to time. You have one set of lawyers who are appearing for 2 defendants at the same time in the same proceeding. One defendant is successful and the other one is unsuccessful and is convicted. What is the cost order that would be made in that circumstance? The rule of thumb approach, as it is known, is that the usual order in that circumstance that will be made is that the successful defendant would get 50% of the costs, being, given that they're using the same lawyers, half, therefore, of the lawyer's costs will be the prosecutor would have to pay, and conversely, the one that was convicted would have to pay the prosecutor's 50% of the prosecutor's costs. This particular case, though, demonstrates that whilst that might be the usual approach, it nevertheless needs to be adjusted depending on the actual way in which the case is run. In this particular case, there were two related corporations, the holding company and a subsidiary. Both of them were charged with, in effect, operating a mine and failing to ensure safety at a mine. The holding company successfully established that it was not operating the mine, that the subsidiary was the only entity operating the mine. That was in part based on material which the defendant had but the prosecutor hadn't seen. When it came then to considering costs in circumstances where the holding company had successfully defended the matter and the subsidiary had been convicted, Judge Kearns then considered whether to apply the rule of thumb and said he wouldn't, because he said 90% of the court time was spent on whether there'd been a failure to ensure safety, and only 10% had been spent on the question of whether the holding company was or wasn't running the mine. So the orders he made, I should add one more thing, when it came to the question of the 90%, he identified that the defence had effectively succeeded on one issue that had occupied about 10% of the time. So the orders he made were the successful defendant, the holding company, would have 10% of its costs paid by the prosecutor, and the convicted subsidiary would have to pay 80% of the prosecutor's costs. Now, the next two issues. Firstly, incapacity to pay. As you'd know, from time to time, defendants come before the court and are able to satisfy the court on evidence, not simply assertion from the bar table, that there is an incapacity to pay. And in these two cases, Albans and Colwell, the court proceeded, I think in both cases, on a consensual position from the prosecutor that the defendant had a serious incapacity to pay. I think in one case the individual was bankrupt, in the other case clearly had incapacity to pay. The first case, Judge Scotting, the prosecutor had come to an agreement with the defendant who had pleaded guilty to pay an amount of costs. And Judge Scotting said, what I'm going to do is I'm going to make that order, that consent order, but I'm then going to significantly lower the penalty I otherwise would have imposed because of the clear incapacity to pay. Judge Russell, faced with a similar situation but no consent order before him, took a different approach in that case and one he cites in that Colwell case, which is to say that in his view, the appropriate approach is to set a penalty which properly reflects the gravity of the offence, and then, if there is an incapacity to pay, simply make no order as to costs. Not because no order should, or maybe more accurately, that the order as to cost should be that the defendant not pay the prosecutor or anything, in light of the incapacity to pay. Finally, the failure to comply with a timetable, the Poletti case. There's a number of... The Poletti case is an interesting one to look at if you're examining this issue from a number of different points of view. There are issues about the prosecutor succeeding in some part, failing in another part. But the part that I'm interested in for the purpose of this final point is that during the course of the proceeding, and not long before the matter was set down, the prosecutor served an expert report. That led to the defence seeking to adjourn the matter on the basis that it would need time to respond to that extra expert report. Then, ultimately, the prosecutor decided not to rely on that expert report, and at the end point, the judge had to consider what order should be made as a result of that, and determined to order, firstly, that the defendant pay the prosecutor's costs, but also order that the prosecutor pay costs to the defendant, being the costs thrown away by the late service of the expert report, the vacation of the original hearing date, the costs thrown away from the vacation of the original hearing date, and the costs of preparing the defendant's expert report. Now, if you look at section 257F, the power is actually limited to the costs arising from the adjournment. The judge obviously took a broad view of that power and added, in effect, the costs associated with the adjournment, which included the preparation of the expert report. A different judge may well have, or in a different case, may well have simply reduced the prosecutor's costs by a similar amount rather than require that to be paid to the defendant. Okay, well, look, that really wraps up what we're doing. Can I just remind you of a few things? Firstly, if you are interested in a longer version of these things, particularly I think Carmel's paper, which in order to fit it in, she gave you a good introduction to, but there's more to be said, perhaps after the High Court hands down its decision, if it does, because there's an application to withdraw special leave in that case. Secondly, a reminder that if you haven't found them yet, the papers that are associated with each of these presentations are available on our website. Go to the Develop tab, go to the Articles tab, and then search within the Industrial and Employment Law practice area. And finally, can I just say, for those of you who are sitting at home watching this, not allowed to go to work or otherwise in social isolation, I wish you and your loved ones the best of health. Thank you for joining us.